Imagine getting a legal document in the mail, a court petition, filed against you. Now imagine it was filed by the person sitting right next to you on the couch, the person you share a bed with, the person you are still fully, completely together with. That is exactly what happened to one woman in New York, and the story raises some genuinely fascinating questions about parental rights, family court, and what happens when fear and bad advice collide with a relationship that isn't even broken. This one is wild, so stay with me. To understand why this situation is so confusing, legally and emotionally, we need to set the scene properly. Our subject is a woman in her late 20s living in New York. She and her boyfriend have known each other since childhood. They've been a romantic couple for years. They had planned to get married. Their daughter, who was 4 months old at the time this story came to light, was completely planned. This was not an accidental pregnancy. This was not a rocky situationship. This was a long-term committed couple building a life together. They live together. They co-parent seamlessly. She works mornings, he stays home with the baby. He works nights, she comes home to take over. Weekends they spend together as a family. By her account, there is not a single disagreement between them when it comes to raising their daughter. He was present for the pregnancy, present for the birth, and he signed the birth certificate at the hospital. On paper and in reality, this looks like a functioning, cooperative parenting partnership inside of an intact relationship. She also has a child from a previous relationship. She is not naive about family court. She already navigates a 50-50 custody arrangement with her older child's father. She has a public defender for that case. She knows how this system works. She is not someone who stumbled into this blind. And yet, she got blindsided. A petition for custody arrived in the mail, at her home, filed by her boyfriend, against her, for their shared daughter, while they are still together, still living under the same roof, still raising that baby side by side every single day. She had no idea he was doing it. He did not tell her. She found out the way you might find out about a lawsuit from a stranger, through the mail. So how did this happen? Let's walk through the story. While she was still pregnant, her boyfriend's mother got into his ear. The mother, apparently with strong opinions about how her son should protect himself legally, convinced him that he needed to file for custody as soon as the baby was born. The fear driving this was straightforward, even if the response to it was not. He was worried that she would leave one day and take the baby with her. He was worried that without a legal custody order in place, he would have no recourse. He would have no guaranteed right to see his daughter. Now here is the thing. That fear is not irrational in the abstract. Plenty of unmarried fathers have faced exactly that situation. They were never married, there was no custody order, the relationship ended, and suddenly they found themselves trying to fight for access to their child through the courts. It happens. It is a real concern, and the law in many states for a long time did treat unmarried fathers very differently than mothers. But here is where the fear meets the facts and things start to fall apart. In New York, when a father signs the birth certificate, he is acknowledging paternity. That acknowledgement carries legal weight. He is recognized as the legal father of that child, and as the legal father, he has parental rights. He is not starting from zero. He is not in some kind of legal limbo where she can simply vanish with the baby, and he has no options. That is not how it works. His name on that birth certificate matters. She tried to explain this to him, repeatedly. She told him they already have equal rights. She told him that if they ever did split up, they could figure out a parenting plan without dragging each other to court, and that if he ever felt he needed the court's involvement at that point, she would support it. She was not trying to cut him out. She was not threatening to leave. She was not doing anything to make him feel like his relationship with his daughter was in danger. He did not hear any of it. His mother's voice, and apparently the voices of others he had brought into the relationship, which she acknowledges has been a pattern and a problem, were louder, and so he filed, without telling her, and now they have a court date next month. So what actually happens here? What does family court do when two people who are together, living together, equally involved in raising their child, show up because one of them filed a custody petition? The honest answer is, It depends, but there are a few likely outcomes. First, a judge may very well look at this situation and raise an eyebrow. Courts generally do not love adjudicating the parenting arrangements of people who are not separated. The whole machinery of custody law exists to resolve disputes. If there is no dispute, if you are living in the same house, making decisions together, both present and involved, then what exactly is the court being asked to decide? That said, courts cannot always simply dismiss a petition just because the parties are together. The petition was filed. It is in the system. The court has to address it in some way. The judge might ask questions. The judge might encourage mediation or a temporary hold to see if the parties can resolve this themselves. The judge might issue a consent order, essentially a formal document that both parties agree to, that establishes custody on paper without any real conflict. That actually might not be the worst outcome, because it would give him the legal documentation he seems to desperately want, while also protecting her from any unexpected future complications. But here is something she should absolutely not do. Walk into that courtroom without understanding her rights. Even if she feels she has done nothing wrong, and by all accounts she has not, family court proceedings have a way of becoming more complicated than anyone expects, especially when there is already a separate custody case involving her other child in the mix. Courts can and do look at the totality of someone's circumstances. She should at minimum consult with a family law attorney before that court date, not necessarily to fight him, not necessarily to escalate the situation, but to walk in informed. There is also the larger issue she acknowledges but sets aside, the relationship itself. And honestly, it is hard to set aside because what he did is a significant breach of trust. Going behind your partner's back to file legal paperwork against them without a single conversation, without any warning, because his mother told him to. That is not a small thing. That is a decision that affects the entire trajectory of their family. And if they are going to have any chance of a healthy future together, that conversation cannot be avoided indefinitely. So what can we learn from this? First, if you are an unmarried parent, understand what rights you actually have before fear drives you to make a drastic decision. In most states, including New York, signing the birth certificate as a father is a legally meaningful act. It establishes paternity. It gives you rights. Talk to a family law attorney in your state. Many offer free consultations before you file anything, because filing a custody petition has consequences that ripple outward in ways you may not anticipate. Second, if you are on the receiving end of something like this, do not panic, but do not be passive either. Get informed. A consultation with a family attorney is not the same as going to war with your partner. It is just making sure you understand the field you are standing on. Knowledge is not aggression. It is protection. Third, and this one applies to both people in this story, be very careful about how much outside influence you allow into your relationship, especially when it comes to decisions that carry legal weight. His mother had an opinion. That opinion, delivered at the right moment to someone already anxious about fatherhood, turned into a court petition that neither of them may have actually wanted or needed. Family members mean well. Sometimes they do not. Either way, legal decisions about your children should not be outsourced to people who are not living your life. And fourth, if you have fears about your relationship and your child's future, talk about them, out loud, to your partner, before they become legal filings. This couple, by her account, was doing everything right as co-parents. They had a system, they had trust, they had plans. All of that got complicated because one person's anxiety was louder than the relationship they had actually built. The court date is coming. The petition is real. Whatever happens next, this family is going to have to sit across a table, whether that table is in a courtroom or a living room, and figure out how to move forward together. And that conversation was always going to be necessary. It just should have happened a lot earlier. If something like this has happened to you, if you have been blindsided by a legal filing from someone you trusted, or if you are the one who filed out of fear and are now questioning it, drop your thoughts in the comments. These situations are more common than people realize, and you are not alone in navigating them. And if you want more content breaking down real legal situations that affect everyday people, custody, housing, employment, all of it, make sure you subscribe. New videos come out regularly, and you never know which story might be the one that helps you protect yourself when it matters most.